Hello. This is Pattyjo. This is part 2, day 1 of the redo of the Darrell Brooks trial. Try to get through this. Thanks for joining.
Working. I do appreciate that he was able to hear me because he leaned in.
It was before, a bit further on, I think. Trying to skip the we're out of the courtroom. Oh, his shirt's back on, so yeah, this must be it. Okay, right
the
there.
Next break that the Sheriff's Department put you in the chair face forward and with shackles on your ankle as you are in custody, and that is appropriate. Now, I want to turn back to the issue with the jury instructions, Mr. Brooks. You indicated you had an objection. My next question to you is, what is the legal basis for the objection? I'm going to unmute so you can answer. Go ahead, sir. You need to turn around so I can hear you. Part of the issue is he's also not facing the microphone, and so I need to hear him, and he needs to turn around.
He's pouting.
Mr. Brooks, I'll ask you once again, what is the legal basis for your objection to the jury instructions?
I have none. Darrell.
I'll ask a third and final time, sir, what is the legal basis for your objection to the jury instructions?
I wasn't loud and attentive. I can't even hear what you're saying all the way now. Too low.
You want your headset?
Mr. Brooks, I can hear the deputies over there. I know they can hear me. That's been confirmed.
Everybody can hear but Darrell.
Available to use should you wish to use it. If you can't hear, I would ask that you put them on. I'm able to hear. He said to the deputy, put them down. I don't want them.
Put him down.
All right, I'm going to mute once again so I continue with my record. He did not answer the question, what is the legal basis for the objection? I asked that question 3 times based upon that non-response. His objection is noted for the record, and I will approve the preliminary jury instructions that are on file with the court. Obviously, they'll be uploaded once I read them, but all parties have been given copies of those.
See, this behavior is exactly what he does probably before in the hearings that were occurring beforehand, all the way through the trial, all the way to the sentencing, all the way. They would get to the parts where they were doing the housekeeping portion of the program, not the evidence and things like that, but all of the things, the instructions, things like that, anything that had something to do with legal things, and he would just try to grind everything to a halt by doing this pouting, narcissistic, gaslighting behavior. Like, I can't hear. Of course he could hear. Otherwise, he wouldn't have said it at those specific times. I can't even hardly hear. And put those down. I'm not going to use them. All of that behavior that you wouldn't expect from a grown man. He is just trying to grind this thing to a halt. And yesterday, what the prosecuting attorney said, Susan Opper, is apparently, and I kind of glossed over it because I don't think I heard it fully, but I think she was referring to phone calls between Darrell Brooks and his family members where he's saying, this isn't going to happen, and I'm just going to, stall this out, and none of this is really real. He's just in an imaginary world. That's something, that there's something really wrong there.
Before I turn to the motion for reconsideration, You raised this earlier, at least the topic of it. Mr. Brooks presented a filing to the court this morning. I asked the bailiffs before the case was called at 8:30 if Mr. Brooks had any paperwork and to ask him if he had any filings. He then provided this piece of paper, and it was photocopied. Actually, it was date stamped, then photocopied for the parties. It may have already been scanned in, I'm not sure, but it certainly will be. I've had an opportunity to review this document. Based upon my review, I don't believe any response is even required. It's his affidavit. He's providing certain disclosures, but there's nothing about that that requests any relief from the court. Certainly no legal statutes or constitutional provisions are referenced. To me, it just looks like an objection that he's filing, and that will be, of course, noted for the record. Attorney Opper, anything you would want to add to the record on this, any position you are taking?
No, I also viewed this as, because he labeled it objection by affidavit, I think my interpretation is he was trying to make a record for appeal that he objects to the court's previous ruling. I don't think there's anything the court needs to do with this document at this time.
He's just trying to jump up and down and make waves and thinking everything's going to stop if he says these things. These are the parts where he's trying to use the sovereign citizen rhetoric to shift everything his way, and he thinks they're legal arguments. If he really believed in this movement, from what I understand, and I'm no expert and I'm no attorney, but from what I understand, he wouldn't have given his name to the police. He would have started all of that with the questioning. And I'm kind of considering going back to some of those and pointing out all of the hypocritical things that he did during that. Even laying down and giving up from that porch kind of goes against anything that a sovereign citizen would do, because they don't think these laws apply. And he obviously tried to play the game differently at the start, and now all of a sudden he's getting these pieces of advice, I guess you could loosely term them.
All right, thank
Trying
you.
to apply
Then
them.
we'll move on to the motion for reconsideration. And again, I'm keeping Mr. Brooks muted so that I can get through this process orderly, efficiently. When necessary, I will.
People say she
unmute
didn't
when
do
Mr.
that.
Court has
She
questions.
did.
All right, Attorney Opera, I have read through the motion. Is there anything you want to add to what you have?
But what I wouldn't give to have that courtroom silenced and us hearing all of this muted stuff, that would be...
Put in your hand.
Only one other observation, Your Honor, that since
Now he
I
wants the
filed
things.
the events of the last couple days, I
didn't
think
want 'em, but now I
further
want 'em.
support my request. Not that the defendant's behavior in the courtroom has anything to do with the broadcasting of victims and witnesses, but I think the stress that is going to be placed upon them potentially by Mr. Brooks' behavior
serious
will be additional challenge to them as they testify, and so not having their faces displayed, I think, would help ease some of that tension for those individuals.
Mr. Brooks, my first question to you is, do you have a position on the state's request in their motion for reconsideration? I'm looking for a yes or no answer.
Okay, my understanding of this particular motion is that the prosecution wants for the victims and or families and or witnesses, because let's be honest, the witnesses are traumatized. There is much more than physical injury that occurred here, and not to downplay that, but I think what has been glossed over is just the harm emotionally and mentally to this whole community, that something that they should have been able to do was so overtly spoiled by an evil deed. And what the motion for reconsideration is that the witnesses on the stand, because they're going to be cross-examined by Darrell the clown, and in the way he's just so disrespectful, is just, that's going to be another layer of harm to injury. And it's true. So they don't want the faces shown, considering all of the bubble of, obviously, I mean, I'm still talking about it. I don't know if anybody else is, but, I probably watched it right straight on, and I'm still talking about it. So it affected me as even a bystander's bystander. So they want the faces not to be shown during questioning, just to level down that insult to injury. And it doesn't matter what the prosecution wants. It doesn't matter if it's going to benefit him or not, or be neutral to him. He is going to disagree on everything with everybody. So that, spoiler alert, that's the way this is going to go, no matter what the thing is. If they had argued the other way, he would have argued opposite. So, they gave him an objection sign eventually. It should have just said interruption, because that's all he was really aiming to do. He very rarely has any true objective legal standing that he presents. But here we go.
I'll unmute and provide that to me. Go
I
ahead.
didn't hear what they said. I just put the headphones on, so I didn't even hear what she said.
Sir, it's a written document that was filed, and you were provided a copy of that yesterday. We took a recess yesterday, so it could be served upon you. If you haven't read it, that's your choice. What I'm asking you is, do you have any position on their request for this court to reconsider the denial of the state's request to prohibit the photography and video recording of victims and witnesses, and specifically their faces, while they testify?
A ruling was already, we already talked about that. You already ruled that the victims and witnesses will be shown. That was already ruled on.
You are correct, but they filed a motion for reconsideration. That's the document that was provided to you yesterday. I'm asking if you have any position on the request that I reconsider my ruling.
Yeah, it was everything's supposed to be public. This is a public trial. I don't understand.
I think this is something that we all have taken for granted. Things that were meant to be a public trial were public to the people who it affected. Public trials, with the advent of television, it got broader. But this, where this is being seen probably worldwide and forever, and you could probably go in and get these pieces for years and years to come on this very, accessible platform. That's not the public, I think, that was put into place way back then. But, this is just his first argument for, why are we even talking about this? We already talked about this, but, his stupid bravado. Okay, moving on, Darrell.
And why there would be even the need
Anytime
to
you want to get
reconsider
to a
what you
point.
already ruled on at this point, as far as to that particular issue.
I take your...
It's a public trial. It's a public trial.
Now he's going to repeat.
Anybody can essentially watch the trial. And like I said, as far as with the technology that we're in now, if they have to be sworn in by name, that in itself makes them easy to, if somebody wanted to pull them up or find them or find out who was testifying at any given time testimony is given, it'd be pretty easy for them to be found and to be seen.
Yeah, that's actually
So,
my
I mean,
point.
that's just the age we're in anyway, as far as with social media and Google and all these different things. We got all this technology basically at our fingertips. So I don't understand how it needs to be changed at this point when it was already ruled that this is a public trial. There's going to be a lot
Okay,
of
stop
things that
repeating
are going to
yourself.
be
Oh,
shown.
jeez.
Why not keep everything public the way that it's intended to be? And because of the fact that you've already ruled on it, made that on a record, let's keep it the way it is.
All right, thank you, Mr. Brooks. I appreciate your legal analysis of that and your factual analysis of the prior ruling that this court gave. I thought you did an excellent job making some very good points, many of which I relied upon previously. There is a mechanism in the law for a party to bring a motion
What is that noise?
for reconsideration. Essentially,
Am I getting... Can I pause this? I'm gonna... Stops in a minute.
it
There it
requires
goes.
that the
Sorry about
party
that. I don't
bringing
know
the
what that was.
motion provide some new information or rely on an argument that the court aired as a matter of law in its prior ruling. The decision that I made previously and the decision that I make here today is one that is vested with the sound discretion of the court. I would note the state does rely upon a case. The case is not new, so it's clearly something that was in existence at the time of the prior motion. That's Estes versus State of Texas. It's 381 U.S. 532, but I would note it's from 1965. In 1965, I would say even in the 1980s here in Waukesha County, there was really a presumption that cameras not be allowed in courtrooms at all. We have moved vastly away from that over the course of the last couple decades, and certainly since 1965. I am certainly mindful of the potential stress that it may cause for victims and other witnesses to come into court and testify and to have their images broadcast as this trial is broadcast, not just locally, but nationally, and frankly, anywhere in the world anyone with a computer would want to watch. I would note, though, that prior to the point in time when this case came to trial, this court took significant efforts to keep victims' names private. There's a victim key that is on file. This court signed an order and even required Mr. Brooks to not disclose that information. That was one of the conditions set when bond was initially set. Now, that was by a court commissioner, of course, but that's still a ruling that this court adopts. In addition, I believe I've done, up to this point, everything that I could to preserve their privacy. I don't, frankly, want to create an issue that could be an appellate issue. I think this potentially could be that if I limit the capturing of victim and witnesses' images. I am aware of Marcy's law, certainly aware of the provisions that the state cites, but the fact remains the time has now come for this trial to be conducted. This is a public trial. The right to a public trial is not only for the defendant, but the state, but the public. all of the names are a matter of public record. This court obviously went through all of the names of the witnesses during the jury selection process. In the jury instruction, the names of all the victims will be read. The state agreed that it was time to put that information in a public document and on the record because the time for trial has come. The cameras in the courtroom not only facilitate the viewing of a public trial where anyone could walk in to this courtroom, space permitted, to watch, but it facilitates victim rights as well. And that is because there are a large number of victims in this case. This court could not have all the victims and the public and the media who wanted to be here present. Frankly, I think it's because of how this court has allowed the proceedings to be live streamed that we don't have even a full courtroom here today. There is no doubt this case has received great public interest, but this is a case that the state brought charges, and rightly so. I understand it won't be easy, it may be messy, it may even be stressful, but it's important to the integrity of these proceedings, the perception of how things are conducted in this courtroom, that all witnesses, that all victims, with the exception of the one thing I accepted previously, be viewed in its fullness to the public. I maintain the exception for juvenile witnesses. They are in a special category as minors, and they, of course, if and when a juvenile.
So my limited understanding of what she's saying is she's going to side with this is going to be a public thing. As she ruled earlier, with the exception of juveniles, which is a normal thing a lot of times, even in the areas where juveniles are in, their faces aren't shown, even if their voices are on, in these court things that we're watching, especially online since COVID and things like that. She did say one thing that I did pick up on this time, which is she didn't want this to be an appellate issue, which is for Darrell to be able to appeal this based on this ruling. She would think it was a mistake, even with this case that they cited, the Marcy's Law, I think is what she said. So, which I don't know very much about either. Again, I'm not an attorney. These are just my personal observations. If you have anything else to add or you picked up on, please comment.
Witness testifies may only be captured from these shoulders down. Their faces are not to be broadcast. Again, I am not unmindful of the impact, but in my humble opinion, the right to a public trial supersedes the other provisions, and especially in a case such as this, it's important. I would add to the record some of the points Mr. Brooks made. Not only are these names all a matter of public record, the technology that we have at our fingertips, there's Google, there's social media. It's very easily to identify these individuals and search for them in other ways. I'd also add that there have been a number of news reports, media accounts, newspaper articles about victims, naming them. I'm aware of one such broadcast this morning on Channel 4. I cannot presume that all victims, all witnesses want this. And I want to keep this trial going, and that's what we will do. So the request is denied. All right, I believe, let me just get back to my first note that I had for this morning, that we've covered all of the outstanding issues.
But I did not hear if you, I was kind of overhearing that you addressed the filing that I filed this morning.
But I was still
I didn't hear exactly what was said. I'm just making sure that you know that I'm not trying to interrupt. I just want clarification on what I may have missed.
When I was
I'll
pouting.
tell you what I ruled previously. I've reviewed the
Okay.
filing. It's entitled Objection by Affidavit to the state's response and the court's opinion and order and defendant's disclosure statement by affidavit. It's an affidavit. It does not request any relief from the court. I have interpreted what you have filed as an objection to be noted on the record.
Now he
It
thinks
has
that's
been
evidence,
accepted.
though.
It has been filed, and that your objection is noted. The court need not take any specific action as it relates to it. I further indicated that, again, no relief was requested, but also there's no statutory or constitutional or law that you cite to that I could even interpret as a request for relief. So that's how I'm going to address that filing, sir. It's noted for the record.
Can I say one thing about that?
Quickly, sir. I need to keep
I
going.
was filing that paperwork. I would say pursuant to the federal rules of criminal procedure under Rule 12.4 about the disclosure statement.
All right, I'll note
so I
that
will-
for the record, sir, but it was not in your filing.
So that's a judicial determination, Your Honor?
I believe I had one other thing. Oh, I did want to put on the record, and that is when we were testing the audio, I did advise the sheriff's department to let Mr. Brooks know, to ask him on my behalf if he wanted to come back into this courtroom. My understanding is he declined.
No, that is not accurate, Your Honor.
Mr. Brooks?
The reason
Mr. Brooks?
I would just want
Hold on, I'm going to mute you for a second unless you stop and listen to me.
I just heard what you said, but I just.
I'm not asking for a response, sir. Mr. Brooks? Okay, you're interrupting. Hold on. You're interrupting me, sir. I wasn't looking for a response. I'm happy to ask you the question myself on the record for you to answer it. I will give you the opportunity to come back into this courtroom. You have demonstrated that you can make cogent, coherent, articulate arguments on the record. You just did that. You've been respectful for the time being. I will
No,
ask
he's
you,
not.
sir,
Look at
do
him.
you want to come back into this courtroom? You've been unmuted to answer that question.
Not until I can receive medical treatment for the bruise that I have on my arm and the cut. You just said a while ago on the
Bruise
record
and
that you
cut.
cannot see blood. That's because I wiped it on my pen.
He has a paper cut and a tiny bruise on his arm. This is a man that ran over dozens of people, knowingly, purposefully. And he's refusing to go back in because he needs the medical attention. Oh my God.
You can still see the blood in the cut and a big bruise right there on my arm. I was told that the nurse would be coming in to see me. And then I was told, no, she's going to come at the next recess, which we just took. I know it was technical difficulties why you called the recess, but that was more than enough time for me to at least be seen, at least get the cut cleaned out and get it bandaged, at least at minimum that, and for somebody to look at this bruise. That was my position on why I was not yet ready to come back into the court, because I feel like this needs to be addressed.
All right, Mr. Brooks, I understand your request. I'm denying the request to take an adjournment, or I'm sorry, to take a break at this time.
I'm not asking for a break. I didn't ask for a break. I was just saying that at the time that there was the technical difficulty recess,
Somebody should have run over and
even
looked
called
at
that,
it.
Your Honor, I was told that a nurse was coming in at that time, but then when you called the recess for the technical difficulty, I was then told that I would have to wait until another recess to be able to be seen by
Until
the
a
nurse.
planned
Which
recess.
my thing was, I
Mr.
wanted
Brooks,
to
you've
get
made
seen
your
by the
record,
nurse.
okay? I don't need you to go further with that. You've made your record. I'm gonna mute you for the time being. I want you to be aware, sir, I was advised regarding the cut. The bruise is new information. I made a determination that you would be seen at the next appropriate break. From my perspective, a small cut and a bruise is not going to hold up the start
Can you see
of
the bruise? That's what he's
bringing
saying.
the jurors in and advising them of the preliminary jury instructions. If that means the next break we take is for lunch and that's when you are seen, then that's what will happen. So,
Where is that? No one cares. Video, I'm sorry. This one. I even have closed captioning on. No one cares, Darrell. No one cares.
I don't think I've overlooked anything, Attorney Opper, but anything you had on your list.
Nothing else on my list, but we want to give Mr. Brooks one more opportunity to change out of his orange jail uniform, excuse me.
That I would give him an opportunity to do. Mr. Brooks, would you like to go back and change into your suit?
My position has not changed whatsoever, and it will not change, as it is my right to come into court how I would like to. Just like I should be
Good.
awarded the right to be present for every proceedings in this trial.
You are present.
I'm muting him again.
More
I
present you
note
deserve.
your objection. I will take that as a clear indication you do not want to go
And change your clothes.
back to
Thank
the
you.
jail to change into street or civilian clothing, that you are exercising your right to dress in the jail attire. All right, then with that, I am going to just take a short recess just to have the jurors
Excellent.
brought in.
I'm gonna take a break here. I think this is a good time to. Oh wait.
Sign,
We'll make sure he has it.
thank you.
Oh, the objection sign. Okay. All right. I think this is a great place to stop and post, and I'm going to see you again tomorrow for part 3. And when the jury comes back, and I'm sure that's going to be, as I recall, a great time. So thank you. Remember all of the victims. Pay attention to that is what this is for. Also, to make sure that we all decompress from this. Thank you. Thank you for helping me learn. And I will see you. Bye.